Then we're told that Tommy is killed and then Arthur dies. So the issue is, what is the effect of those deaths on the ownership of the land? If you haven't already explained the effect of the right of ownership in your answer, then you should do so here. But if you remember, I've already done this, so I wouldn't repeat it again. So here's my application of the right of survivorship to the facts, and we pick it up from after Tommy severs. He then dies, so the right of survivorship applies in relation to the legal estate because they were all joint tenants. And in terms of the equitable estate, Tommy was a tenant in common, so his share passes under his will to Grace because the right of survivorship doesn't apply. And you'll see that I've expressed the fractions in eighths. I went back and did this when I was working out my final answer, and you will discover why I did this shortly. And this reinforces something that I mentioned earlier, that you should work out the final beneficial ownership in your rough plan before you start to write up your answer in full. Then Arthur dies. He was a joint tenant in both law and equity, so the right of survivorship applies. So now Polly and Esme are joint tenants of the 3/4 or 6/8 share of the equitable estate, and Grace remains a tenant in common of the quarter share because she didn't benefit from the right of survivorship when Arthur died. So moving on, the facts then explain that Esme agrees to buy out Polly's share for £60,000. But the agreement was never put in writing, so it's just an oral agreement. And the issue is whether that oral agreement operated to sever the joint tenancy. And the key case is Williams and Hensman, which, as I mentioned earlier, explains the circumstances in which the common law recognises a severance, and in the case, various methods are described. So I'd look at these methods of severance and see if any of them might apply here. And the common law does recognise that acting on your own share as a method of severing your joint tenancy, and that would include a binding agreement for sale. So if we apply that, well, we know that the agreement wasn't in writing, so it isn't a binding contract because the Law of Property Miscellaneous Provisions Act 1989 Section 2 requires that all contracts in relation to land are in writing. So we can conclude that the agreement did not operate as a unilateral severance by Polly. So now the issue becomes, can an unenforceable agreement for sale operate as a severance? And back to Williams and Hensman, where the court confirmed that severance can occur by mutual agreement of all the joint tenants. And the main case on this is Burgess and Rawnsley. And the case tells us that a mutual agreement for one joint tenant to buy out another will act as a severance, even if it's not an enforceable contract. So if we apply that, well, Polly and Esme were the only joint tenants and there was a concluded agreement for sale. In other words, they weren't just negotiating for sale, they had reached a final agreement. So we can conclude that a severance occurred by mutual agreement. So let's see how that applies to the facts, and here's my table, and we pick it up after Arthur dies. So Polly and Esme end up with 3/8 each, and Grace still has a quarter share, which of course is 2/8. And now you can see why I had to go back and amend my fractions earlier into eighths. And as a tip, I would suggest that this is probably as complicated as an answer is going to get in terms of the mathematics that you're going to have to use. So as I mentioned earlier, if you end up with something which is a truly horrendous fraction, quickly go back and recheck to make sure that you haven't made an error earlier in your plan. Next thing to happen is that Polly dies. The right of survivorship applies in relation to the joint tenancy of the legal estate, so Esme becomes the sole surviving legal owner. And in equity, Polly's share passes under her will to Michael because the right of survivorship doesn't apply to a tenant in common. So my final advice regarding the current ownership of the property is that Esme is the sole surviving trustee and legal owner, and she's holding the property on trust for herself, Michael and Grace, and the shares are 3/8, 3/8 and 2/8 respectively. So now I move on to the second part of the question, in which we are asked to advise Michael and Grace whether they can force a sale. And here are the final facts, and you'll see that Michael and Grace want to sell the property, but Esme is refusing. And Esme's 17-year-old stepson is now living there with her and his father. And we're also given some information about their individual circumstances. So the issue is, can Michael and Grace force a sale? That's what we've been asked to consider. The rule is that only the trustees have the power to sell the property, which in this case is Esme, who doesn't want to sell. So we can conclude that Michael and Grace can't sell themselves. So the issue becomes whether Michael and Grace, as equitable owners, can apply to court to request a sale. And the rule regarding who can make an application is in section 14 of the Trusts of Land and Appointment of Trustees Act 1996. And I would state the relevant text from section 14, which you can see on the slide there. And if we apply that, well, Michael and Grace do have an interest in the land because they are beneficial owners. So I would conclude that they are able to make an application to court. So the next issue becomes, is the court likely to order a sale? And the relevant law is in section 15, which sets out the relevant factors that the court is required to consider. But I would also explain from the outset that this list isn't exhaustive, so the court can look at anything that it considers to be relevant, and also that the factors are not equally weighted. So some factors may play a more important role in the court's decision than others, depending on the circumstances. Before we move on, there's just a couple of tips for you. If you are allowed to take a statute book into the exam with you, then use it here to remind yourself of the relevant factors. And note that any sensible discussion of how the courts might apply the factors in the relevant case will receive credit. So never simply say it's up to the court to decide. What you must do here is look at the relevant factors in section 15 and suggest how the court might approach them. And also make sure that you leave enough time to deal with section 15 properly. I'm sure that you will appreciate that in terms of legislation relating to land law, this is probably one of the easiest you will encounter. So don't throw away these easy marks. They're there for the picking. So now I need to identify the factors which might be relevant here and apply them to the facts. And the first relevant one is in subsection A, and this is referring to the intention of the original owners. And we know very little about why they acquired the property, but we do know that they all lived there together initially. So we can assume that that's why they bought the property together, as a home for them all. And the only one of the original owners living there is Esme, so this is unlikely to be given a great deal of weight. Subsection B refers to what the current use of the property is. So who is living there and why? Well, Esme is living there with her husband and stepson as her home, but her co-owners are not living there. So the fact that it's only occupied by one of the current owners is likely to be a significant factor. Subsection C would also be relevant here because there is a minor, Freddie's son, who's living in the property as his home. So the court must consider his welfare when deciding whether to order a sale or not. But because he's very close to the age of majority, he's 17, and because he's only recently moved there, I would suggest that this isn't likely to be a significant factor. And then we have the final relevant factor, which in this case is likely to be extremely significant. And the section states that the wishes and circumstances of the beneficiaries must be taken into account, so what they want and their circumstances, and if there is a dispute, as there is here, then it's the circumstances and wishes of the majority of beneficial owners which is taken into account. And when working out who is in the majority, you look at the value of their combined shares. So you don't look at the majority in terms of the number of joint tenants in equity, you look at the majority in terms of the value of their shares added together. When we apply this, we can see that it's Michael and Grace who together own the majority share because they own 5/8 as opposed to Esme's 3/8. And we also look at their circumstances. Well, we know that Michael is desperate to sell because he's deeply in debt to loan sharks, and Grace wants to sell because she's no longer living in the country. So on balance, I would conclude that the court is likely to order a sale. And finally, here's just a couple of tips here when applying section 15. First of all, you should identify all possible relevant factors and apply them to the facts. Don't worry if they conflict, so if one points to a sale and another points away from a sale, this is quite common, so don't ignore it. Explain that they conflict and you will get credit for your discussion. Very often there isn't a right or a wrong answer to this part, and remember that it's not an exhaustive list, so any relevant information will be taken into account. So that's my answer plan. Thank you for watching, and I hope that you found it helpful. I would be really grateful if you would consider subscribing to my channel or like and share my video because it really does make a difference. I'm Amanda and I'm a former lecturer who now works as a private land law and trust tutor. Once again, many thanks for watching.